to Texas Law TV. Today we are going to be talking about dog bites. The statistics from the American Veterinary Medical Association state that 4.5 million Americans are bitten by dogs every year, and 1 in 5 dog bites requires medical attention. My guest is attorney Greg Anderson, and he is going to talk with us about this important topic. Greg, thanks for being here today.
Thanks for having me.
Well, Greg, what if a neighbor's dog comes into your yard and bites your child and there are injuries that require medical attention? Whose insurance policy pays those medical bills?
In the state of Texas, we do not have a statute that covers that situation, but we do have what's called the one bite rule. What that means, and it's a little bit of a misnomer because it doesn't just cover bites, but basically the concept in Texas is if your dog has been known to demonstrate dangerous propensities in the past, has either bitten someone or seemed like it was going to bite someone, then you are charged with that knowledge and you have a duty to protect others from your dog. If, on the other hand, your dog had never shown any dangerous propensity, never bitten anyone, never seemed to threaten to bite anyone, and then bite someone, probably there's not going to be any responsibility, with some exceptions, on the dog owner.
Okay, can you explain the concept of dangerous propensity from a legal perspective?
Sure. Dangerous propensity just has to do with whether or not a dog is known, or any animal is known to be a danger to other people. So if a dog has bitten someone, then you clearly know that dog has a tendency to do that. Or even if a dog just is known to chase after people, lunge at people, growl or bark at people all the time, a homeowner or a dog owner would be charged with that knowledge that that dog could certainly do something like that, and has an extra duty to protect other people from harm from their pet.
Suppose your child was injured in a neighbor's yard by their dog and that the child was actually harassing or teasing the dog. Does that affect the liability?
Yes, it certainly could. Texas is a comparative negligence state, which means that the conduct of the injured person is also taken into account. So in the case of a very young child, by law, a very young child cannot be negligent or responsible for his conduct. So if a 3-year-old is harassing a dog, so to speak, and the dog bites him, then that child's conduct is not a factor in that situation. On the other hand, if a 17-year-old who should know better does something to harass a dog and the dog bites the child or the kid, then that could be a problem in terms of liability and who's responsible. It certainly could be partly the fault of the 17-year-old.
Greg, do other states treat dog bites differently than Texas does?
Yes, they do. Many states have what are known as strict liability laws, in which it doesn't matter whether or not your dog has bitten someone before. All that matters is that that is your dog and it has then bitten someone. The homeowner or the dog owner at that point would be responsible for the dog's conduct. So they don't have this one free bite rule that we have here in Texas.
Well, that's all the time we have for today. Greg, thank you for being with us.
Thank you.
Until next time, this is Dee Lynham for Texas Law TV.